Hello, welcome to the Commercially Savvy Lawyer. My name is Sonia Shekun, and I'm the Commercially Savvy Lawyer. Today we're going to talk about commercial terms. Commercial terms is a huge subject, and there's no way we can possibly get through all the commercial terms today, but we'll talk about it on a high level and discuss the importance of getting it right. The biggest challenge for any transactional lawyer, especially in a cross-border transaction where you're dealing with lawyers for whom English is not their first language and it may be their second or third language, it's imperative to accurately reflect the parties' commercial intentions in your contract. Sometimes the contract will arrive with the commercial terms fully baked, and sometimes you will be part of a negotiation team where you will see the contract terms develop before your very eyes. So Contract Law 101 taught us that a contract is an offer, an acceptance, includes valuable consideration, mutual obligations, a writing typically, although we know that you can have a contract by conduct, and the parties have to have the legal capacity to contract, to be the age of majority, typically 18 years or older, and the parties have to be mentally competent. A contract is the written manifestation of a party's intentions, and it is deceptively difficult to get this right. A bilateral contract between two parties follows a set formula. In this series, we will be going through each element of the contract and discuss drafting hacks, tips, and potential pitfalls to avoid. So let's start with the parties' rights and obligations. We will be galloping through that. And bear in mind that this is not comprehensive. You will always have to do your own research and you'll develop your own style, ask questions of people around you who are also lawyers or sometimes engineers have better legal drafting knowledge than lawyers do. So anyway, the parties' rights and obligations. You really need to concentrate on this and think outside of the box sometimes. Oftentimes, you will have the purpose of the contract. So let's go back to the example I used in my earlier video of the cleaner and the law office. The purpose of the contract is for the cleaning company, let's call it New York City LLC, to provide cleaning services to Shekun Law. So in that situation, it really doesn't matter how you organize it, just so long as you include all of the rights and obligations of each party in your contract. Because should the relationship break down the line, and it goes before a mediator or a judge or an arbitrator, you don't want to be in a situation where you assumed that certain rights and obligations would be included, because what's written in the contract is typically what the contract comprises, and that is further compounded by a clause that you'll find in your boilerplates called the entire agreement, but we'll get to that later. Your contract is a how-to guide for the people who are going to be implementing the contract, so please get it right. So a quick example, you can organize it per party. So New York City Cleaners LLC can have a section where you outline the cleaner's rights in one section, and those rights might include to have a safe, warm, or cool environment depending on the season in which to work, the provision of cleaning supplies if it's the law firm who's going to be providing the cleaning supplies, to be paid on time, and to be unobstructed from providing the services. Its obligations will obviously include providing the services according to industry standard. That may include best or reasonable efforts. Let's keep that discussion for another video because it's a little bit more involved. Providing insurance. If there are people coming, especially during COVID, this is often the case, you need to provide workers' compensation insurance. And then submitting the invoice if that's how the payment terms are constructed. It's not always going to be the same. You have to look at your contract holistically. You have to look at the purpose of the contract. Sometimes the scope of work will be a couple of sentences, which will be expanded in the rights and obligations, and then fully fleshed out in a schedule, which is incorporated in the contract. And it really depends on the level of complexity of the contract. Obviously, for a straightforward cleaning contract, where it's just a simple weekly clean in a commercial office, the terms won't be so complicated. But if you have a multi-million or multi-billion dollar contract for the provision of goods or services, it's important to really think about what the contract looks like in practice, get into all the corners of what the contract will look like in real life and not just on the paper, because, as I said, if the contract relationship breaks down and you have to go before a judge or arbitrator or mediator, you can't argue, but we agreed or I assumed. It has to be there in black and white. Thank you so much, and see you next time.